Thank you so much, Elle. Welcome, everyone. We're really excited you could join us today. I want to go ahead and introduce our presenter. So we'll have Paula Hannaford-Agor. She's the director of the Center for Jury Studies at the National Center for State Courts. Some of you may recognize her. She's joined us at the ITWIG before. She obviously has a lot of expertise in this area and is really looking forward to hearing from all of you some of the issues that you're seeing with your courts and getting jurors to respond to summons, thinking about how to reopen and hold jury trials in the time of COVID. So I think it'll be a really good discussion today. I did want to add into additionally to Elle's comments. So we do encourage a really lively discussion today. We'll have, sections of the presentation will be formal presentation mode. And then we'll have a few points at which we're going to open up for breaks, both breaks and having folks, chime in, let us know what you're experiencing. If you have any questions, we really encourage you to ask them. Please feel free to use both the chat or the raise your hand feature. My understanding is depending on which version of Zoom you have, the raise your hand feature might be in two different areas. So it's either going to be in the reactions box, or if you click on participants and go to the bottom, it'll be listed there. And again, Elle is available to troubleshoot any issues, so just feel free to chat her. And we'll also have a few polls today, which we encourage everyone to participate in. So with that, I'll go ahead and turn it over to Paula for our strategies for increasing responses to jury summons. Thank you.
And thank you very much, Esther. And I'm just delighted to be here this afternoon and to see everyone. I'm going to just share some slides very quickly. So what Esther had asked me to do is actually a couple of things. One is certainly talking about how to make sure that when you are summoning jurors for jury service in SDVCJ trials, that they are actually appearing for service. And so there are some tried and true strategies that state courts have used over time that actually help to really minimize the number of failure to respond and failure to appears to be looking at. Before we get into that, I also wanted to, particularly for those of you who are just in the very beginning of doing some of your implementation strategies, just a little bit of a brief overview of just the provisions of the SDVCJ requirements for jury trials, what does a fair cross-section mean, and some of that information. So just to get into this, let's see, now I need to get here. There we go. So probably most of you are very familiar with all of the provisions of 25 USC 1304. The one that we're going to be focused on today is in Section D. In a criminal proceeding in which a participating tribe exercises special domestic violence criminal jurisdiction, the participating tribe shall provide to the defendant the right to a trial by an impartial jury that is drawn from sources that reflect a fair cross-section of the community and do not systematically exclude any distinctive group in the community, including non-Indians. Now, the language in this provision is actually really close to the language that has been traditionally used by state courts and federal courts interpreting the Sixth Amendment to the US Constitution regarding the right of a defendant to a fair and impartial jury. One of the key phrases that is used in a lot of the case law is when you define what an impartial jury is, part of that definition is a jury that is selected from a fair cross-section of the community. And so there's actually a lot of language in there. And I raise that obviously because the Sixth Amendment does not apply to tribal courts. You are sovereign nations. But the statute itself does in terms of how that goes. And so looking at this language of how do federal courts over time have interpreted what it means to have a fair cross-section is probably how federal courts would approach the same question if there were actually a challenge to to the tribal courts how they put their jury pool together. And so I just want to spend a couple of minutes on that. So the main case on fair cross-section, it's really kind of the seminal case, is one called Duren v. Missouri. It was a 1979 case actually involving gender discrimination. Mr. Duren had been charged with first-degree murder in Jackson County, Missouri, which is where Kansas City is. Interestingly enough, the arguing for Mr. Duren before the Supreme Court was none other than Ruth Bader Ginsburg as an advocate when she was heading up the women's rights group for the ACLU. Duren came out with what is really the seminal test to establish a prima facie violation of the fair cross-section requirement. And it's a three-pronged test because the U.S. Supreme Court just loves three-pronged tests. The first of which is that the group excluded is a distinctive group. And by distinctive group, most of the case law is referring to what in equal protection jurisprudence is called immutable characteristics. Typically, it is race, ethnicity, and gender. In a couple of instances, it's been extended to religion or national origin, but usually most of the time they're talking about race or gender. So that's the first prong. The second is that the representation of the distinctive group is not fair and reasonable in relation to the number of persons in the community. And that's actually a really loaded and heavily packed phrase. And I want to come back to that in just a second. The third part is that underrepresentation is due to some type of systematic exclusion. Systematic exclusion does not necessarily have to be intentional. It just needs to be somehow inherent in the way that the jury system is actually operated. So it's not the same as an equal protection claim that you have to prove intentional discrimination. You just have to prove that it's something that the court itself can control. And most of the cases recently that we've seen that have shown systematic exclusion, more often than not, it works out to be a problem with the jury automation, just a programming error that has left off significant portions of the jury pool. That's just to establish a prima facie violation of the fair cross-section requirement. If a defendant actually meets all three, proves all three prongs, then the burden shifts to the state to basically demonstrate that they've got a compelling reason for the exclusionary practice. So for example, one of the basic qualifications for jury service in both state and federal courts is that you have to be a U.S. citizen. As a result, in many counties that have large immigrant populations, you've got sizable numbers of maybe Hispanics or Asians that are excluded from the jury pool because they are not U.S. citizens. And so part of the compelling justification where there have been cases on this point has basically meant that jury service is not only a requirement and a civic obligation, but it is a privilege of citizenship, and requiring people to be citizens of the United States to be eligible for jury service means that they understand and they've been acculturated with an appreciation for these kind of democratic norms of jury service. That said, the states retain a lot of discretion in terms of who is actually qualified for jury service, who is exempt from jury service, and how the jury operations actually work. I think for tribal courts that are trying to implement the SDVCJ provisions here in terms of fair cross-section, that leaves you with a great deal of discretion also in terms of who is qualified as a non-Indian. And this is where I wanted to come back to this whole question on that second prong of when is representation of a distinctive group, in this place a distinctive group being non-Indians, who are serving as jurors in tribal courts. How is that not fair and reasonable? For the tribes, it means you get to decide who of the non-Indians who are part of your community, where is that dividing line? And I think that becomes particularly tricky for those tribes that are not, who are less geographically defined, of all the tribal members that are living within a particular geographic area that is the reservation. So in those tribes that actually have individual parcels of land, for example, in eastern Oklahoma, that's a very different kind of thought process than you would see, for example, in state courts, where the jurisdiction of the state court is defined by the county borders, or particular state borders, if it's a federal court, for example, that might have multiple counties. And so they're defining sort of the eligibility of people, of those people who are living there, who are adults over the age of 18, U.S. citizens, residents who actually live there full time. Those are the typical qualification criteria that we see in state courts. For implementing tribes, that's actually one of the first challenges you have, is trying to decide who is in the community of the tribal court, particularly in those tribes that don't have those geographical boundaries, that it's all people who are living here. So that's a little bit of a background in terms of the case law and some of the issues that you might have. Esther, were you going to mention something?
Nope, I don't have any comments. Thank you.
Okay, all right. So part of the thing that the implementing tribes should be doing is actually setting out some of those questions of who is the community, what does the jury pool look like, in a jury plan. And the jury plan is typically a written description of all of the procedures that the tribe uses to summon and qualify prospective jurors for trial. Typically, it's adopted as some sort of formal expression of court policy. I know from looking over some of the tribal codes that many of the implementing tribes actually have their jury plan has actually been incorporated into the tribal code itself. So there's a section in there that talks about jury trials, and here are the people who are eligible for jury service. Either if the tribe has traditionally done jury trials or is just beginning to do SDVCJ trials now with this new legislation. So it might be a bifurcated, where for SDVCJ trials, you have non-Indians in the pool, and otherwise it's just tribal members in the pool. If you haven't already done that as part of your tribal code, it's actually very useful to have it as a written policy for a couple of reasons. The first of which is that it is actually really helpful for just transparency, of letting anybody who is coming and just knows what are the procedures and who is eligible for jury service. What are the different, how long are people on the hook? What's the term of service? Things of that nature. It's also really good, particularly over time. If you have turnover with your judges, turnover with your clerk of court, turnover with other people in the justice system, just for training purposes, that there is something that is written out so that it doesn't just get passed down orally, from one person to the next. And then finally, just for accountability, so that there's something definitive there, so that people can actually look and say, well, okay, your tribal code says this, your jury plan says this. Is that in fact how this particular panel of jurors were summoned and selected for this trial? So some of the essential components to be thinking about as you're drafting a jury plan, certainly you want to be putting in anything about the statutory and regulatory authority of the court itself, of the tribal court. What's the jurisdictional authority of the court? In this case, certainly with SBVCJ trials, you would want to be citing that particular provision of the U.S. Code. You would want to include a description of what your master jury list is. So a description of what sources of names that you are using for people who are eligible for jury service. If there is any possibility that you're going to have duplicate entries, how do you actually identify those duplicate entries and remove them so that the people who might have their names on twice, as an example, somebody who is a tribal member but is also on a list of people who are residents or lessees of the tribe or a tribal employee, that they would end up being on the list twice. That person would have twice the likelihood of being selected for trial if that were the case. And that's actually a violation of random selection, basic principles that everybody has an equal probability of being selected. So if you are doing anything in terms of removing duplicate entries, some description of what are the matching criteria, first and last name, address, date of birth, whatever those criteria are. Some statement of who is qualified, age, residency, any other type of qualification. A lot of state courts also use the ability to speak and understand English, because in state courts, all the trials actually take place in English, and so it's very important that the jurors be able to understand the proceedings as they're going on. As well as a lot of states have prohibitions on people with criminal history. There's also the thought of who is exempt from jury service. You might want to have people who are actually occupational exemptions, people who are actively involved in the tribal criminal justice, as a tribal police officer, tribal judge, tribal court employee, prosecutor, defense counsel. It might be not, less appropriate and look like a conflict of interest for those people to be actually on a jury. How you're selecting, how you do randomization, what is the size of your juries? Do you have a 6-person jury? Do you have a 12-person jury? And what is required in terms of the verdict decision? Does it have to be a unanimous verdict or a non-unanimous verdict? So those are some really basic pieces that we often see in terms of a jury plan. Other useful pieces are to just talk about, who can be excused. If somebody is having some type of very severe hardship, they would have to travel a long way, or they have health problems, and that would actually interfere in their ability to serve. Under what circumstances if you summon somebody, will you say, okay, you don't actually have to show up? Or is there a deferral possibly? If you've summoned somebody who's an accountant during tax season, can they say, can you please get me after, well, this time May 17th, but normally after April 15th, because I'm kind of busy right now. Terms of service, are people part of the pool and sort of on call for jury service for a full year, for several months, for just a month? So how long would people actually be eligible and subject to being called in for jury service? If you are compensating them with some type of a jury fee or reimbursement for mileage, for example, or reimbursement for childcare, those are good things to actually include in the jury plan. And as well as, and this is where we'll spend most of our time this afternoon, talking about summons enforcement policies. when you summon jurors, if they fail to respond or fail to appear for service, what happens? Are there any consequences? Are they subject to criminal contempt or civil contempt? Is there sort of a presumption of a fine? What can happen to the person to make sure that this is a jury summons, which is technically a court order? I mean, it is a subpoena to appear at court. So how do you make sure that the people who are being summoned for jury service understand that it is worth at least the cost of the paper that it's written on? Wanted to talk for a couple of minutes about the.
Oh,
yes.
Sorry. Do you want to? I just want to. Should we pause and do a couple of our polls, or do you want to hold those?
I just realized that when I got there that I just skipped by our first poll, didn't I? So that was supposed to have been back here in terms of your jury plan. So now would be actually an excellent time to run that first one. Let me take the screen down here. So this one, have there been, for those of you who have actually put in place a jury plan, have there been any legal challenges?
Great, and we'll give it just a few more seconds to see. We have a few responses coming in. Great, so we'll wait till we get about half of our attendees responding. So for any folks who are multitasking and turned away from your Zoom for a moment, you want to jump back and answer the poll, that would be great. Okay, I think we can go ahead and end this poll. Thank you.
Okay, so we out of the responses, so thus far, the people who are responding, there have been no challenges have been filed or threatened, with one where it's been threatened, but it hasn't actually been filed. So I'm curious if we could just stop for a second if there's the person who's brave enough to come forward. I would love to hear about what the allegations were about that particular.
Feel free, I'm checking the chat. We do have one comment from Colleen where she mentioned Passamaquoddy has had situations where a juror is held in contempt for failing to appear for jury service once they've been selected. So slightly different topic, but wanted to make sure you saw that one. And so we'll go ahead, and if anyone wants to talk more about the situation in which a challenge was threatened to the jury plan, please feel free to raise your hand. You can also send a message in the chat. You can also send a private message to me if that would feel more comfortable. So otherwise, I think we can go ahead and move forward.
Okay, all right. So let me go back then to the slides. Actually, before we do that, there was a second poll that I think we could probably do first, and that was the one of just, for those of you who are doing your jury plans, if you could tell us a little bit about what the status is. So Al, if you could run that poll. So this is if you could just describe what's the current status of your tribal court jury plan for SDVCJ.
Great. We'll give it just one more second, see if we get a couple last votes. Okay. All right, I think we can go ahead and close the poll. Thank you.
Okay, and so obviously we have from this we have tribes that are in different places. Several of you have got a written jury plan. It works really well. A couple of you want to modify it to better meet your needs. And then a couple of you are sort of just in the process of developing a written plan or thinking about what you actually want your jury plan to look like. So at different places. So hopefully, this webinar this afternoon, for those of you who are working on it, will give you some ideas. All right, so back to sharing the screen. All right. So just talking a little bit about this, this idea of, what is the ideal master jury list? And this comes down to, sort of the challenge that those of you who are sort of working in tribal courts needing to think about who is in your community, who are the tribal members, the Indians, and who are the non-Indians that are part of your community. So your ideal master jury list really has three characteristics. One, you want it to be representative. And in state courts, typically they're talking about representative at the very least geographically and demographically, usually by race and gender. You want it to be inclusive. And these are actually, representativeness and inclusive are really very complementary thoughts. If you could develop a master jury list that had everybody who is potentially eligible for jury service in your community and excluded no one, that by definition, if it's 100% inclusive, it would be 100% perfectly representative. It's only when you have lists that are under inclusive, maybe your tribal roles have people that are living well, geographically well far away from where the court is, and you kind of realize that they're not going to be there, and so you're using tribal roles except for these people who live more than 50 miles, more than 100 miles from the courthouse. So that would be under inclusive. It's not including all of the tribal members, and so there's a possibility that those tribal members who do not live close to the courthouse, there's always the possibility that they have a distinct, distinctive characteristics, opinion, attitudes, or other characteristics that would make your jury pool less representative. That's sort of the mindset that state courts and federal courts come to it. The other piece of it that I think gets overlooked in a lot of places is that it's just really important that the address records be accurate and up to date, because it doesn't matter how good your list is in terms of inclusiveness and representativeness. You could have an absolutely perfectly inclusive representative list, but if you can't actually deliver a jury summons to that person, it is functionally useless. So that's one of the things that you want to be, thinking about as you are considering sort of what lists you're going to use to make up your master jury list. What do you know about the quality of the addresses? Is this actually going to be helpful for you when you are mailing out jury summonses and hoping that people will actually show up, 6 weeks out for the trial? Some of the potential source lists that typically get used, we've seen in terms of tribal courts, obviously tribal roles, tribal membership itself. For many of the tribes, it can be actually, it doesn't necessarily have to be a member of this tribe. It could be any Indian, any Native American, so membership in another tribe. Often in terms of the community, it could be spouses or adult children of tribal members who themselves are not Indians or are not members of the tribe. Residents or lessees on tribal land, tribal employees, either casino employees, Indian health, Indian government, tribal government employees who are non-Indians, could be, you know, your potential source of non-Indians. The other place to go, and this is probably for those tribes that are not as geographically centered in terms of reservation land, of just looking to either the registered voters or licensed drivers, state identification card holders that are in that area, that are, you know, either in the townships that you know, that are interspersed, you know, close to, adjacent to tribal land, with non-Indians that are, you know, familiar with, you know, that are essentially your neighbors. So that's another area. I know we've got a poll here because we were curious as to, for those of you who have developed this, of who are actually the source list that you're using. And this is a check all that apply.
Great. So again, for if you're listening, multitasking, and you've minimized your Zoom window, go ahead and open it up. We have a poll. Oh, perfect. We see a few. There we go.
Yay.
And we'll give it a little bit longer with this one. I know it's a lot to read, and since you're checking multiple options, give it a little bit longer. All right, looks like we're slowing down, so we can go ahead and probably close this poll and display. Perfect, thank you.
Okay, so we're sharing the results here. So this is actually kind of interesting of where the different source lists are coming from. Obviously, all of you, everybody who answered the poll said that tribal members who live on or near tribal land. 2/3 have any tribal member, regardless of where they live. Any person who lives on, who's a resident of tribal land, that's about 90% of you. Non-member spouses and non-member adult children, so a little over half. Non-member employees, that one again is closer to 90%. Residents of tribal housing or lessees, about 44%. Non-member residents of the local community, about 1/3, and then other, because we have to have the ubiquitous other on any of these polls. So, okay, wonderful. So going back, so obviously there's been many fewer jury trials this past year, and just wanted to talk a little bit about just what the jury trials look like in COVID. One of the things, I mean, for state courts, and I think what I've heard over the last couple of, you know, ITWIG meetings and calls, is that most of the tribal courts, like most of the state courts, largely suspended jury trials, particularly starting a year ago, March, and through a good portion of 2020. There were some state courts that actually did stay doing jury trials throughout the pandemic. And a lot of them that, started back up in the fall, but then closed them down again when we had the surge last winter. Couple of the things that has really, prompted a lot of problems for state courts, and I expect for tribal courts as well, is just the amount of backlog. One of the things that we realize about jury trials is a lot of them get scheduled. They often don't actually end up going to trial. But most state courts, and I assume that probably many of the tribal courts also have this experience, that it is the trial date itself that is the mechanism for actually getting cases to resolve. And as the trial date gets closer and closer, both the prosecution and the defense counsel are taking a much closer look at the evidence, who is likely to testify, can we actually prove beyond a reasonable doubt these particular charges? Are there problems or holes in the evidence on one side or the other? And typically that's when you start serious plea negotiations. One thing that we've seen in terms of COVID is that without actually having a firm trial date, if the court is, we're not doing jury trials right now, that firm trial date as a motivator is kind of a paper tiger. It's just not focusing people's attention on, okay, we need to actually get serious about this. Are we going to try this case? Or are we going to dismiss the charges or plea to some other charges? So probably a lot of you have some backlogs, both criminal and possibly civil cases. In state courts, we've seen some big impact in terms of the characteristics of the jury pool. One of them has been with excusal rates, and this can be because people are being excused because they're at high risk for COVID. They're elderly, they are people of color that have had disproportionately, severe health effects. So excusing a lot of people, undeliverable rates actually have not been as bad in state courts as we were thinking, largely because a lot of the eviction moratorium were in place, and so people were staying put. And so the undeliverables have not been as bad as they could have been. We are anticipating, though, that once as these moratoriums expire in state courts, that there probably will be a lot of the addresses, it's pollen season in northern Maine, which is where I am right now, so I apologize. But yeah, we're certainly anticipating in state courts to see the undeliverable rates tick up. And then others are just people who, again, non-response and failure to appear rates, largely with people who are just quite fearful about coming down to the courthouse, of being in large crowds of people, not knowing what to expect, having to take public transportation, and so just failing to appear. And so COVID has had some real significant impacts in that respect. One thing that we've seen from state courts that have been doing jury trials is that they can really mitigate a lot of those impacts by how they do their public messaging about what they're doing to protect public health and safety. So anybody who has ever been to jury service and it's large crowds of people, it kind of looks like it would be a super spreader event. Just explaining to them that, yes, people will be required to wear masks, that we will enforce social distancing, that, there are maybe health screenings at the courthouse entrance, to, temperature checks and looking for symptoms, excusing people who, if they are symptomatic, or if they have tested positive for COVID, or they've been exposed to someone, yes, by all means, we would prefer that you actually stay home and self-quarantine and not infect other people by coming in for jury service. So a lot of the public messaging, I think, is really important. I'm anticipating for state courts that the really slow rate of jury trials, because in a lot of state courts that were used to, starting multiple trials on the same day, just can't do that in their courthouses because of social distancing requirements. So it's jury trials are resuming, but they are going very, very slowly and very carefully, and continuing to keep in place all of that CDC guidance, even for people who are fully vaccinated at this point, just partially because jury service is compulsory. It's a court order, it's a subpoena to appear in court. And so it's not like sort of an individual can decide for themselves, well, I'm perfectly fine, I'm fully vaccinated, so I'm fine eating at a restaurant indoors now, versus other people saying, no, I'd still rather not be around lots of people right now. Because jury service is compulsory, I think courts do need to be more careful. And I know the state courts are being, very cautious about how they resume jury trials. One thing that I think is going to be particularly important for a lot of the tribal courts, particularly those of you who use tribal employee lists, is thinking about whether or not those lists, if you had them in place from early in 2020, if those employee lists are still valid, or if you need to actually refresh your list with new tribal employees. I know for a lot of the casinos, certainly in 2020, like many other sort of entertainment venues, a lot of the employees were either furloughed or laid off because you couldn't actually have the casinos open. So that's something to be thinking about for the tribes as you're resuming jury trials, is to just look back over your list and think about, are these people, particularly the non-Indian tribal employees, are they still eligible for jury service, or are they in fact not employees of the tribe anymore, and you might need to actually replace them with new names. So now let's sort of get to this meat about the non-response and failure to appear. This is actually, it's a problem for state courts everywhere. On average, we know that probably the non-response failure to appear rate tends to average about 9% nationally. So out of every 100 people that get summoned, approximately 9 of them will not show up. But I've certainly worked with some state courts where that range has been as high as 50%. And I think that it's really important to think about sort of what some of the myths are of, who are these people who don't show up. In state courts, there's a lot of the myths that, well, they're just bad people. They're irresponsible, they're not civic minded, they don't trust the justice system. And that actually is very much of a myth. Studies that have been done about sort of the attitudes of people who fail to appear for jury service. What are the real things that are going on? Often it's because they didn't actually receive the summons. We've done studies, have looked at them, a real seminal study that was done by the American Judicature Society in 1998, of up to half of the people who failed to appear for jury service, in fact, never received the jury summons. And that was sort of, they would send in a couple of those jurisdictions where they were following up and, trying to do order to show cause for people who failed to appear, and sending the sheriff out to deliver the orders. And the sheriff could not actually ever locate the people. So that's a piece of it. And I think that just re-emphasizes how important it is to have accurate address records. for the half that, didn't show up when they asked about them, typically the response is, well, I honestly forgot. Typically, courts are summoning jurors anywhere from 4 to 6 weeks ahead of trial. And so, you get the thing in the mail and maybe you get it on the calendar, maybe you don't. You set it on the side of your desk at home, stick it with a magnet up on the refrigerator. But people are living busy lives, and some of them actually do forget. Some of it may be just sort of a post hoc excuse, but some of them actually do forget. What we do see with a lot of them is that many of them don't understand that if there truly is a hardship, they don't have transportation, they can't afford it, they're in a work situation that they're being paid hourly, on an hourly basis, and they're not going to get paid for the time that they miss for jury service. And they don't understand that if they call the court and ask, make a formal request to be excused, that the court might in fact actually excuse them or make some other accommodations for them. And so there's some of that sort of confusion about what to do, and so you end up with people who, well, this is really it's a bad time for me. I can't be off work. My car broke down and there's no public transportation, whatever that is. And instead of calling the court, they just don't show. And so one of the things that's really important is making sure that when you're communicating with jurors and the jury summons and any other information that you send, that it includes information about, if you have a problem, please call us. We'll work with you. So one of the things, part of that Judica AJS study that was done that looked at this and said, what are the reasons? What is the single biggest thing that we can point to about whether or not when you summon somebody, are they going to appear for jury service or not? And they looked at socioeconomic status, they looked at race, they looked at education, they looked at income, they looked at all of these different factors. And the thing that they figured out that was the single biggest predictor about whether a person will show up for jury service is what they think the consequences will be if they don't. And I think you can't underestimate this enough. Those jurors who, if they get this jury summons and they think, well, if I don't show up for court, if I don't show up for jury service, I'm going to get arrested, I'm going to get fined, a judge is going to yell at me, something bad will happen. And it doesn't matter whether or not that bad thing, they're not going to get arrested or something like that. It doesn't matter whether they truly understand what the bad consequence is. They just know that something bad will happen if I don't show up. Those people will show up. The people who say, well, nothing will happen. It really doesn't matter. They won't miss me. When push comes to shove, those are the ones who are going to say, okay, I'm not going to go because there are no consequences to my not going. And I think that really is the key certainly for state courts, of making sure that that the juror who is getting this summons actually understands and believes and has the messaging that this is really important and bad things will happen if you don't show up. Once you actually get them in the courthouse and you can talk to them about jury service and how important it is and sort of your contribution to the court and to the justice system and pride and civic engagement and all of those wonderful things that go along with jury service, then you can impress on them once you actually have them in front of you. But first you need to actually get them in the door. So this one cartoon that I had here, oh, they'll find us, I have jury duty. That's exactly what you want people to believe, that the court will track you down if you don't show up. So what we talk about in terms of best practices for state courts is if you have a juror who doesn't show up for jury service or who doesn't respond, is make sure that you follow up on them. And the major objective that is you want them to serve if they're qualified and available. This is not intended to be punitive. You might actually have some consequences where you can fine people or have any other type of negative consequences. But the point is having that sort of stick in hand so that they actually serve, not because you really want to fine them. What state courts have found is that the single thing you can do is basically having a second summons or a second notice. That's where person doesn't show up, and so you send them a new summons, and here's your new date, and here's the list of terribles that will happen to you if you don't show up or if you don't call. And what we've seen from state courts is that those that have done nothing compared to those that have just that single second summons, second notice, have their failure to appear rate reduced by almost half. So it's really powerful. I think Colleen mentioned for Pasquayakis that another thing is basically to issue order to show cause. These can be very effective, not so much for getting that juror to serve, but using that as sort of a public education of getting the news out about these scofflaw jurors who got in real trouble, so that people actually understand in your community that there are negative consequences. They tend to be time and labor intensive, so that just having one of those dockets. But if you're having real problems with failure to appear rates, just doing one or two of these order to show cause calendars, and invite in if you have whoever's doing the tribal newsletter, newspaper, radio, anything like that, just so that people in the community are hearing, and that the next time they get a jury summons, they're going, oh yeah, I remember what happened with so and so. Remember all that bad press. You do, and depending upon the volume of trials you're doing, sometimes if there's a lot of problems, you might want to just not do everyone, just do your worst offenders, or a random selection. I do think that one of the things to be careful about is to screen out what we call sympathetic jurors. The picture there is actually an editorial from Kankakee, Illinois, a judge there who was very concerned about their cross-section and was really doing a lot of follow-up on failure to appear. Basically put in place in order to show cause, and this was like a third notice. And of course the day comes up and he has all the local media that are there for the jury scofflaw calendar, and the very first name that comes up, it was a little blue-haired old lady with a walker who's hard of hearing, of Edna. And so the whole media story was not, court gets serious about jury service and juror scofflaws, and the headline changes to court beats up on senior citizens. So that is something that to be thinking about if you're doing an order to show cause, that if there's a reason that you think that I know that person and I know that they were calling because they've been ill, or they've had, some other types of problems or something like that that are going to be really sympathetic, that may not necessarily be the poster child that you want for your order to show cause. The other thing to do is actually be very preemptive. A wonderful study that was done in Riverside, California a few years back, I think 2012, just started doing postcards. So they were summoning their jurors about 6 weeks out. And then the week before the trial, they were sending postcards to the jurors. And they did this, they did basically a sample, an experimental design, where they randomly selected 1,000 people who had been summoned, and actually 4,000, so 1,000 of each. So 1,000 were their baseline of people who got no reminders whatsoever. Another 1,000 of them got just a postcard, just a plain reminder, hey, you've got jury service on this date at this time. A third version that was the civic duty reminder. So, this is jury service. It's important for your community. This is your civic obligation. It's important to the justice system. Yay, yay, rah, go jury service. And then the fourth version of the postcard was the enforcement reminder of you've been called for jury service, and here are all of the horrible things that will happen to you if you fail to appear. And so compared to the baseline of people who didn't get reminders, they saw the appearance rate increased from just the plain reminders from 65 to 71%, from 65 to 70% for the nice, jury service is a wonderful thing, you should do this for your community. And then jumped 10 percentage points from 65 to 75% for the enforcement of this is the horrible stuff that will happen. So this kind of preemptive thing, it takes away some of the excuses of, oh, I forgot, of just kind of priming the person as, hey, there's a jury trial, it's coming up next week. We're really expecting you. We're looking forward to seeing you. This is going to be a great thing. So doing that, a lot of courts have now taken it from just mailing. And if you have the opportunity as part of your process to get either email addresses or cell phone, telephone, text numbers that you can use, a lot of courts are using just text and email notifications the day before. Hey, you've got jury service. This is important. If you, we're looking forward to seeing you. Please be there at 9 a.m. Promptly, and any other message that you want to put with that. But again, it takes away the excuse of, oh, gee, I forgot, when they're getting a reminder, sort of a wake-up call the day before, or fairly close in time. And it does actually impress on people of, hey, this is not something that the court is actually paying attention to you, and is expecting you tomorrow morning. So it reemphasizes that. So at that point, I'm just going to stop talking and see if there are any questions or thoughts.
Great, thank you so much. Thank you. I will skim through the chat. Let's see. Okay, so we had one additional comment, I think maybe clarifying an earlier comment from Pasquayaki, that Pasquayaki does not issue an order to show cause for failing to appear for jury summons. That the situation was where referenced earlier was where a person appeared and was selected but didn't return for their jury service the next day. Okay, thank you. Okay. Yeah, so I don't see any other, I'm scrolling through, but I don't see any other questions in the chat. So I did want to, again, we're opening it up. I see, let's see, looks like Judge Demert has her hand raised. Judge Demert, go ahead.
Good afternoon, everyone. Thank you, Paula, for your informative presentation today. It was really good, and I always enjoy listening to you. Question, it's not necessarily related to special domestic violence court jurisdiction, but mostly just jury practice. I inherited a system in which we essentially set a jury trial every single Wednesday, and in order to meet the speedy trial requirements. And it just seems like it's not a great way to manage, the docket, and because, these cases just keep getting pushed out farther and farther, and they get resolved. We set up to 6 per week, and then and most of them get resolved. We maybe have 2 to 4 a year in a good year, right? So we are starting to try scheduling them every other week with settlement conferences on the alternating weeks. But still, that's a lot of work for already taxed tribal courts staff. And so I guess I'm just really curious as to any resources about how to manage a jury schedule, that is consistent with rights that people have, if that makes sense.
Mhm. Yeah, it does make sense. And this is that ongoing dilemma that you have about stacking cases for trial, all on the same day or something like that, and trying to figure out what is the optimal number, because you need to, ideally you'd like to have at least one of them. If you're going to all the work to summon jurors and get prepped for trial, you'd like to have at least one of them actually go to trial periodically. But at the same time, you don't want to stack so many that all of a sudden you have 2 or 3, and what do you do with 2 or 3 trials that are all ready to go? So part of it is there's a couple of different ways of doing that. One is just to use your pretrial conference with the attorneys a little bit more aggressively, to try and resolve those cases. So you can have a trial date that is set, 3 weeks from now is when the trial is actually scheduled. But 2 weeks before, of actually spending that time with a pretrial conference of going, is this going to happen or not? And really pushing very, very hard on that process, to identify the cases that are actually really serious and will go to trial versus the ones that, no, we're actually pretty close to, to some type of a plea agreement or dismissing the charges or whatever is actually going on behind the scenes. Colleen raises a good point about having plea deadlines, using those that, here is the deadline for, if you're going to enter some sort of a reduced plea agreement, it needs to happen at least by the week before the scheduled trial date, because if we're going to go to all the trouble of getting geared up for a trial, and then have you decide on the day of trial that we're not going to do it, and we've got all of these people here. The courts that have done that have usually done that either with financial incentives, so they're paying for all the juror fees that if you plea out on the day of trial, and or having the defendant needs to plea up to the full indictment. So it becomes really it's a two-edged sword. There's certainly risk for the defendant if they don't actually plea. If there's a reasonable plea on the table and they decide not to take it, that they end up having to go with maybe much more serious charges on the day of trial if they decide that they don't want to go forward. By the same token, the prosecutor needs to be really clear and really sure about that they have the evidence to go forward, because if it gets to the trial and the plea is not on the table and you don't have, the prosecutor is not in the position of actually dismissing the charges or doing a last minute plea, then the prosecutor actually has to be able to prove all of the charges. I saw that Colleen mentioned, and maybe Colleen, can you talk a little bit about how that process works in Passaiaqui?
Sure, and I know Melissa's on the line too, and she's her chief public defender, so I invite her to weigh in as well. So I know that we do have situations where what we do, even short of getting the court involved, we will send out a plea and say, the plea is going to be revoked after such and such a date, which gives us an idea, at least from the attorney standpoint, as to whether or not the case is likely to settle. Now, we do have cases that negotiate up until the 11th hour because there are last minute developments and things like that. But I know that at least with our prosecuting office and Melissa's office, the Office of the Public Defender, that when we have a case where we think there are going to be those last minute negotiations, we usually try to let the court know well in advance and at least get the jury trial off of the calendar. But when we do that, obviously, you know, it's with the agreement of the parties, you know, we're basically waiving time for the purposes of negotiation. Melissa, did you want to add anything?
No, that sounds about right. Thank you.
Mm-hmm.
One other thing, and this is more of a sort of a calendar trick to think about, Judge Demmert, is trying to consolidate the what's called a trial term. So right now you have them for every Wednesday. What you could do is just basically do it, you know, maybe, you know, 2 or 3 days, one week a month or 1 week a term. Where you're really consolidating all of the trial activity in that one plate, in that one time period. And I've seen it in particularly in rural courts that don't have a very high volume of jury trials. Will do it that they will set a lot of cases for trial. Knowing that most, if not all of them, will actually flee out ahead of trial. But if they do run into the situation where they, you know, 2 of them are saying, yeah, we had 20 set and 2 of them actually really want to go, that they can do those in 2 consecutive days. And so they will bring a pool in, pick a jury for one case and say, okay, we need you to come back on Thursday, and we're going to start trial then, and then pick another jury to hear the first case, do that one, and so you're just kind of running through. That's sometimes a way of doing that so that you're consolidating all of it in a very brief period, and then during the other weeks of the month, or you know, if you've got a 6-week trial term, that you've got 5 weeks that you're not frantically trying to prep for trial, if that makes sense.
Yeah, I mean, we still have, you know, we have cutoffs in order to send out jury summons. It just seems like we're really depleting the pool by having juries, you know, summoned every month, and it doesn't happen. They get desensitized, so they don't show up. I mean, it's just sort of a vicious cycle, honestly. And we just need to figure out scheduling a little bit tighter in order to. I mean, I don't know how we could do one a term when we have a 90-day requirement for out of custody.
So with the is the issue that you're just running through too many jurors and you're having them come in once a week?
Well, no. One of the issues is, I mean, we have a call-in line, so
Okay.
they don't necessarily come in, but it's a lot of work to prepare for jury trials. I mean, it's like we should probably have a dedicated employee, but you know, tribal courts are underfunded and understaffed, and you know, we have people doing multiple jobs, and so it's more of the person power issue, and how do we, you know, handle that in a small system, but a pretty big caseload without perhaps the, you know, resources that make it easier to accomplish.
Okay. And are you doing, so with the call-in line, is it the same pool of jurors that are calling in every time, or is it new people every time?
They get summoned for a month, and so they have to call in. Yeah. And so,
4 times.
yeah. And so we send out 90 letters every month. And we still have a hard time seating people. So, you know, I would be interested to hear how other, you know, busy courts handle their jury trial scheduling with, you know, because it is very unique in a tribal situation compared to a state. States have far more resources than we do.
Yeah, and it sounds like you're running also on a much tighter time frame with a 90-day trial.
Mm-hmm.
Is your speed trial requirement?
Yes.
Okay.
That's what our Constitution, that's what the Washington State Constitution, you know, I know, I think I've heard where Arizona is like 6 months or something like that. But yeah, you know, I wish we had that time period.
I was
Okay,
gonna say,
maybe, you know, maybe I can call you separately or something, Paula, and, but you could just think about it.
absolutely, absolutely. Yeah, I'd be happy to talk with you and just brainstorm some ideas. So,
Okay, thank you very much.
all right, great.
And I did want to, you know, on that same note, open it up for anyone else on the line. We will be sharing out Paula's contact information, and that's, you know, same offer kind of applies. Anybody has a particular situation that you want to talk through and really have more one-on-one TA, we're working with Paula to arrange that. So just let us know if you want to drop it in the chat or email me separately. I'll add my email to the chat, and we can coordinate that. So next, we did have a question from someone who I think had to jump off, but I'd like to pose the question anyways, and we can follow up with her via email. And so the question was whether human resources are conflicted out for paying court employees. And Paula, I don't know, I have an interpretation of that question, but I'll you.
So that I've seen different states have done it differently. Typically when the, and ideally you'd like to have the employer continue to pay their employees when they're on jury service, because one of the things that happens that people can't appear for jury service is because they can't afford to. They can't afford to take the time off. But what we do see is that if the employer is actually paying for jury service, then the employer can also demand that the employee pay back any of the juror fees that they get from the court, as just as a way of doing it. And typically with public employees, I think this is the case in California, pretty much everywhere, that if you are a state or county employee, then you just say that you're a state or county employee and they don't pay you. So I think you don't want to encourage double dipping, so that the person's not actually getting their paycheck and the jury fee for showing up for jury service, but you don't want the person to be out of pocket entirely. So how you actually juggle that, you can probably look at a couple of different ways of doing that, of just what is going to logistically be the most straightforward and the least amount of paperwork, which is time consuming and costly to figure out.
Great, thank you. And I'm curious in terms of, you know, for human resources who maybe are being called to serve as jurors, is there any issue there?
I wouldn't think so. I mean, the whole thing is you want people who can be fair and impartial, and I'm trying to think if there's anything about being a human resources employee that would make you biased in any way. Maybe I'm missing something, but I'm not sure that sort of being conflicted out because you're the one who's signing the paycheck at the end of the day is a real problem.
Great, okay. All right, well, I don't see any other questions in the chat. Let me just skim to make sure there's no hands raised. We did have one more poll that we can maybe go ahead and run and give folks a last couple minutes to think of any additional questions. So we'll go ahead and run that. Thank you.
So for this poll, this is how many that you've done ever, not just in the last year or so, but since I think we're coming up on 8 years.
Great. Okay, we have another couple seconds and looks like we're slowing down in terms of responses. Okay, we can go ahead and close the poll. Thank you.
Okay. So we've got a few that looks like we're just getting started, so I look forward to seeing the first jury trial.
Great. Well, again, not seeing any additional questions. Paula, if you want to maybe go ahead and put your email in the chat, that'd be great for folks if they have follow-up questions. Again, you can reach out to me as well, and we can help coordinate that. So I want to thank everyone again for joining us. I want to give a special thank you to Paula for presenting today. It was, again, really informative. We covered a lot of topics. And then I also want to thank the National Council for hosting us on Zoom today. So we hope everybody has a great rest of your day and a good rest of the week. We will be posting this webinar recording on our website, and I'll send that out in the next ITWIG email. So thanks so much. Have a good day.
Thank you all.